Hey everyone, thanks for joining me for today's video. We've got a handful of different so-called sovereign citizen cases to look at, each happening in different courtrooms. Before we jump in, I want to quickly say sorry for the slower upload schedule. I ended up taking an unexpected week off while traveling through Europe, and it pushed everything back a bit. I appreciate your patience and support. Now, let's get into it. We're starting with a recent case that appeared in Judge Perkins' courtroom. It's a short clip, but we've got 4 videos to go through today. So there's plenty to break down. Let's get started and see what happened.
Detroit versus Nathan Lucas. Case number Nathan Daniel Lucas. Case numbers SP 106-84961, SP 1111617, counts 1, 2, and 3. SP 11116371, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not in
No?
the etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction.
Acquiesce or acquiesce? Because after you opened your mouth, acquiesce how you would need to clarify to the rest of us that you're a living man and not a living brain donor.
Okay.
Because that issue is to be brought up in my pleadings and filed with a court.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with a court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Hannah here. I'll enter a not guilty plea on your behalf, sir. I'll give you a $0 bond, and I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir?
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that will be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m., all right?
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right, well, I'm entering in for you, all right? Have a good day, sir. I'll see you back October 21st, 2024, God willing, all right?
Is it pronounced aqua or aqua? Once you start speaking, it becomes important to clear that up so everyone understands exactly what you mean. You can see why people in the room might need a little clarification. It helps them follow along and know you're presenting yourself as a regular person trying to explain your point clearly. Being direct and clear with your words makes the whole situation easier for everyone involved, and it keeps the conversation moving without confusion.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
What's Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. Sorry.
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice.
All right, that wraps up the first hearing, and it looks like things are going to get pretty interesting on October 21st. I'll be traveling again around that time, so you and I will probably be reacting to that one together all the way from Amsterdam. Now, let's move on to the next hearing. We're heading over to Judge Gair's courtroom, where we have a familiar face, a returning sovereign citizen I've covered before. This time, he decided he wasn't going to appear for his scheduled court date, which led to a bench warrant being issued. Law enforcement later picked him up and brought him in, clearly showing the authority he keeps insisting the court doesn't have. It sets the stage for another unusual appearance. So let's take a closer look at what happened next.
He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you. Ms. Gitters, people's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case.
Bad advice. Come on, That's more than just bad advice. It's the kind of thing everyone knows shouldn't be taken seriously in the first place. There are certain choices in life where calling it bad advice is really just another way of saying it's something you clearly should avoid, especially now, when there are plenty of people online, including myself, trying to counter this kind of misleading information with basic, practical guidance. We share this information so others don't get steered in the wrong direction. The goal is to help people make better decisions, understand what's going on, and stay away from ideas that can create unnecessary problems. It's all about keeping things clear and grounded in reality.
So this was really quite a willful refusal to acknowledge even the authority of the court, and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority, and that he would, he's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
So let me get this straight. According to that idea, someone could just go out, break the rules, and then tell the court they don't agree with the laws, and that would somehow protect them from any consequences? That doesn't make sense at all. If that were true, imagine how many people sitting in prisons right now would have simply avoided all trouble by writing a note saying they don't accept government rules. Clearly, that's not how anything works in the real world. Laws don't disappear just because someone says they don't recognize them. Accountability doesn't vanish because a person uses a certain type of pen or makes a special statement. Courts rely on actual legal principles, not personal declarations. It's a good reminder that these claims may sound bold online, but they fall apart immediately when tested in real situations.
Whitlock.
Whitlock. All right. Mr. Whitlock, you have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not proceed to the, I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am, I don't consult to the proceedings, and I would like to say things like, I already know how it goes.
And honestly, that's exactly how it should be. Let this serve as a reminder, or even solid advice, for anyone who has family depending on them for stability, food, and a safe place to live. Choosing to ignore the law while also refusing to acknowledge basic legal responsibility can lead to serious consequences that affect not only you, but the people who rely on you. Now we're heading over to Georgia, where we have 2 individuals who identify as sovereign citizens. Both are using wheelchairs, and each has their own way of misunderstanding the legal system. Their situations are different, but both show how misinformation can lead people into unnecessary trouble. It's a good example of how important it is to stay informed and grounded in reality, especially when dealing with legal matters.
With the things about crossing guard lines, I'm in a boat, and I was with the officer the whole time. I told them they need to use their cameras here because they found a bud of weed in my boots.
I'm not sure you fully understand what you're saying, because you just mentioned that you don't consult or concede to these proceedings, which isn't even the phrase usually used by people who follow that script. They normally say they don't consent to the proceedings. And is anyone else noticing the strange detail here? He's currently in a wheelchair, yet he's facing a charge involving fleeing and trying to get away from officers. It's a confusing situation all around, but regardless of all that, he's about to make things even more complicated for himself. What he says next takes the situation in an even more surprising direction, and you can see how quickly things start to unravel.
Mr. Woodlock, you say you know what's going on, so you know this is being streamed live. So
I know, but that don't say I'd rather be charged for that than when they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is gonna get thrown out because the officer was just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Whitlock, this is not a hearing. I don't have the officer here, so when we have the hearing, all this can be brought forward for your preliminary hearing or for your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
If I say I do not consent with these proceedings though, and I do not accept the terms, like.
Okay.
Yeah,
well, you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man.
Okay.
What you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, I thought I had to deal with Fulton County on that instead of Clayton.
Looks like you have some Fulton charges as well. So
yeah, but the Fulton County charges is someone else. That's what they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me?
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park, it is on or around July 28th. It happened. So that is not the Fulton County one that appears to have happened around July 17th. So there's
Clayton County.
Yeah, the warrant was sworn out for Clayton County. Yeah.
Okay, ma'am. That's all I was asking. Because I know that's going to get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not worried about it. I know there's BS.
Wait, so your father works as a detective, and you still believe you can simply refuse to follow the laws he's committed to enforcing? That's a surprising way to look at things. You would think being around someone in that profession would give you a clearer understanding of how the legal system actually works, that I'd ask you to explain how this makes sense. But honestly, there's no reasonable explanation that could justify that kind of thinking. It's one of those situations where the logic just doesn't hold up. No matter how you try to frame IT really shows how misinformation can lead people to believe things that fall apart the moment they're compared to real life.
But it's like this one thing. Those charges that I have in Fulton County, those warrants, I had got locked up in front of the legends on Old National. I know this not, I just want you to understand. I got locked up in front of the legends on Old National. I have 2% in the legends. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen I was clear, I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm going to stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and explain.
I need some professional help.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm going to have an attorney for the charge, but since you're a judge, you can tell me, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors. There's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia. Yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are
You say, talk to my lawyer, right?
Yep.
And even if I say I demand a bond immediately?
You can ask for a bond as many times as you want, but the rules don't work that way. You were already on probation and then picked up new felony charges. And under the law, specifically Georgia Code 17-10-1, anyone on probation who faces a new felony must be held without bond until they have a revocation hearing or a bond review in front of a superior court Judge S.O. The bottom line is simple. You won't be released today. The court doesn't have the authority to grant bond in your situation, and the statute makes that very clear. Now, let's stay in Georgia for our final hearing. This one is short, but
what's your name, sir?
I am Moore. Special representation. I'm asking you.
Your Honor, his name is Tyrese Breland.
Breland?
That's not my name.
Oh, Breland.
That's not my name. I am Moore. I'm here on special representation. I'm asking.
Same as last defendant, Your Honor.
My Honor, I'm asking.
Okay.
What is your status and what is your name? I'd like to know your name. I'd like to know your status. Or everyone in the courtroom, I would like to know what is your nationality and what is your...
So, Deputy.
Yes, ma'am.
I would like to know your nationality.
He has charges in jots and he has a paper charge. Let me see if they're the same warrant. And they're different warrant numbers. Okay. So I guess I do both sets. Let me see when these are.
Know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again, my honor out.
Is he deputy?
Status of everyone in the courtroom.
Is he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is mental health, or do you think it's just a citizen?
Can you provide me with the information?
Both.
that really sums it up. At this point, if someone decides to follow groups that promote incorrect or misleading legal ideas, whether it's the Moorish Science Temple of America or any other organization spreading the same misinformation, they're putting themselves at risk. These beliefs can lead people into serious legal trouble and create problems they never needed to face. That it's important to understand that relying on false legal advice can harm both the individual and the people around them. When someone follows these ideas, they can end up making choices that affect their freedom, their family, and their future. The safest and smartest thing anyone can do is rely on real legal guidance, stay informed, and avoid paths that can lead to unnecessary consequences.
Can you provide me with the information?
All right, so I'm going to give you your charges.
Charges for what? Are you a U.S. citizen? Are you a U.S. citizen? My honor, are you a U.S. citizen?
Sir, be quiet.
Are you a U.S. citizen?
I said be quiet.
Are you
Be
a
quiet.
citizen? What is your name? What is your status? What is the status
Yo,
of everyone in
chill.
the courtroom? That's what I'm asking.
All right. So y'all just go ahead and take him back. I'll go ahead and put the bond. Y'all take him.
Get up,
Asking
move your
for
feet.
the court to be a jurisdiction of the court.
Hey, you might want to chill out.
I'm challenging the jurisdiction of the court. Challenging the jurisdiction of the court because I am not who they say they are. I am challenging the jurisdiction of the court.
No.
Everything is challenged. I'm challenging the jurisdiction of the court.
Hey, let me get two.
Let that know. I am challenging the jurisdiction of the court.
All right, everyone, that wraps up today's video. I've got one more courtroom video featuring a wild Karen before I head back to the US, so stay tuned for that. If you enjoyed today's video, go ahead and hit that like button. If it wasn't your favorite, feel free to hit dislike, but either way, leave a comment down below and let me know what you think. Don't forget to subscribe and turn on notifications so you never miss any of my upcoming content. Thanks for watching, and I'll see you in the next one.